Thank you, Sam. Good day, everybody. Thanks for joining us. We are going to do exactly what that lengthy title indicates. We're going to talk about developing written policies, written procedures within your institution that basically explains how you handle third-party claims. Now, if you are brand new to this topic, I'll just give you the guarantee right now, you're going to feel pretty overwhelmed in just a few minutes, because there's basically three areas that you must be familiar with. You've got to be familiar with the laws of your state. You've got to be familiar with the recent federal regulations that govern how we handle third-party claims when there are government payments involved. And then finally, you need to be familiar with IRS levies. I'm going to review each of those things before we get started with the process of developing policies and procedure. But I'm not going to do it in any great detail. Those of you who are already familiar with those, please forgive, but it is necessary that I make sure everybody is on the same page in terms of their understanding before we get to the specifics of the policies and procedures. One of the things that is absolutely an issue probably for all of us is the recent development of the new federal regulations that affect the way we handle third-party claims when government payments are present. But a side issue from that is, for the first time, federal functional regulatory agencies, the OCC, the Federal Reserve, and the FDIC, are going to be reviewing that part of your process. There are actually examination procedures included in the materials that were sent out to you, and we will talk about them. But there's no question that is what spurs part of the interest in this particular topic. So in terms of the information regarding state law and garnishments and so forth, that information is going to be unique to your particular state. They're on page 3 in the materials. And by the way, most of my remarks will be generated from the handout, which is highly detailed. The information on the slides, they're basically just mile markers that you should be able to look up and say, okay, where are we? But the real information is in this manual, and it is detailed enough, I think, to serve as a resource for you for some considerable period of time. But as I mentioned, there on page 3 is a list of the things that you should be familiar with in connection with your state. Now, on page 4, I have included, if you will, an example from a make-believe state. It doesn't reflect the laws or the regulations or the court procedures in any particular state. I've just pulled in some of the major issues. And for the discussions for this particular program, these assumptions will reflect my particular analysis of this state. And I just want to go through some of these, starting with the bulleted list there on page 4 of your materials. In this particular make-believe state, we have a garnishment order that is signed under oath by the judgment creditor's attorney as an officer of the court. It's based on a good faith belief that the garnishee has assets belonging to the judgment debtor. Well, if we didn't have any problems to begin with, we now have all these terminology issues. When we talk about a garnishment, under the federal regulation, there will be a specific definition for what is a garnishment or what is a garnishment order. Your state may call it something completely different, and that is indeed part of the orientation process. You need to know what the document itself is called in your state. I made a reference to the judgment creditor. Well, the judgment creditor is the person who has sued your customer already, and they won a court judgment against the customer. And then I made a reference to the garnishee. Well, the garnishee is your institution. You're the one who has received the garnishee. You're the one who's received the garnishment order, so that makes you the garnishee. And then finally, there's the reference to the judgment debtor. In this conversation, that's going to be the customer. That's going to be the person who has assets within your institution, the person who has, A, already been sued and lost, and has perhaps accounts or deposits with your institution. So the first thing you need to do is be familiar with the terminology in your state. Of the 5 or 6 terms that I've already used, none of them make the common terms within your state. So that's why, as was indicated in the brochure, we're not going to attempt to talk about the laws of any particular state. But I do want you to develop a synopsis, and perhaps this one can serve as a time saver for you. In the second bullet, it talks about receiving a payment with the claim for doing the processing. That is required in the laws of some states, that if they're going to send you a garnishment order, they have to send you a payment in connection with the garnishment order. The third bullet, circle that one, because that's a really critical distinction that you need to be familiar with in the laws of your state. Some states, the garnishment is a snapshot. It means exactly what it sounds like. So like they took a photograph of what was in the account at the time, perhaps even at the moment when the garnishment was received. And they get what was there, but they don't get anything that was deposited the next day. It is not a continuing garnishment. Some states do have continuing garnishment. The claims continue to exist against the account days, weeks later. Depends on the terms of the order or the terms in the state statute. Again, working our way through our bulleted list, in any state, that's the example, that's the jurisdiction that we're in at the moment, there's been a court decision that decides that the amount that is subject to the garnishment is the amount as of the moment of the garnishment's receipt. That type of a court decision would generate a requirement, I think, that the bank actually timestamp garnishments when they are received, or timestamps any third-party claims. I think you'll see that later in our procedures, that this particular bank does time and date stamp garnishments or other third-party claims upon receipt. It also instructs the garnishee, remember that's your bank, to put a hold on the judgment debtor's account up to the amount of the garnishment. This new federal regulation is going to affect that, and I'll explain why in just a little bit. But it's clear what state law or state court procedures or state court cases want this institution to do. They want that institution to put a hold on the entire balance in the account. Now, we'll find later that if there's a conflict between the state law and the federal garnishment regulation, the federal garnishment regulation will control the situation. In any case, back to the bulleted list, I, again, just want you to look through this and say, okay, what is it in our state? The statement could be completely wrong in connection with our state. Go on to page 5, and perhaps I'd like to pick out a couple more. The first one in this particular state, if the garnishee finds that the customer has no assets or it has no relationship with the customer, that state tells the garnishee how to respond to the court order. And the phrase that I'll use only as an example is simply no assets found. And that would have to be accurate. In this state, they say that if you have assets that belong to the judgment creditor, but they are pledged or they are impaired, in other words, perhaps your bank has a time deposit, but it is collateral for a loan, in this bank, you don't respond no assets found because you did find assets. Tell the court what you have and why you believe that asset is impaired in connection with this particular claim. And one last thing that I want to mention about this particular state, the fourth bullet from the bottom. In this state, and it's common, it's not just one-off situation, in this state, they hold the garnishee bank, that's you, responsible for the entire amount of the judgment if you fail to deliver the assets you were supposed to deliver. For example, you had $2,000 that belonged to the debtor. The amount of the judgment was for $50,000. If you had $2,000 and you failed to deliver it, then your bank would be responsible for the entire amount of the judgment, $50,000. For many years, I have advocated and done programs on developing policies and procedures for third-party claims against customer funds. This program wasn't put together in response to the federal regulation because, frankly, I think failure to comply with the garnishments and levies and so forth imposes upon your institution a far greater amount of liability. So it is the issues regarding garnishments and the presence of federal benefit payments that's generated a lot of interest. But my interest in, like I said,